Hi everybody, I'm Gwendolyn Sterk here with Amy Schellekens of our office, and we're going to talk about a to-do list with parents with children of special needs. It's interesting, isn't it? Your child's going to turn age 18 and you're really not prepared to know what the next steps are. So can you tell us, Amy, what you'd recommend to a family?
Sure. I think your first automatic step, if you're not already on the PUNS list for your child, you need to be on the PUNS list immediately.
Okay, what the world is the PUNS list?
The PUNS list is the list that actually Illinois maintains to make sure the child is pulled off of that list to receive services. You can put your child on that PUNS list long before they turn age 18, so that you're actually on the waiting list and can be pulled from that list sooner rather than later once they turn age 18. But if they're not already on the list and we're approaching the age 18, we got to get on it now so that we can get those services.
Well, what kind of services are we talking about?
We're talking about anything from maybe we're looking at a group home in the future. We need to be on the PUNS list to be able to pull from that list to get those services, or in-home care services, occupational, physical therapies, those kind of things.
Now, in addition to making sure that your child's on the PUNS list, when they turn age 18, should you consider a guardianship?
Absolutely. If the child has turned age 18 or is going to be turning age 18 and we don't feel comfortable with them making their own decisions because they're not going to make decisions in their best interest, a guardianship is absolutely necessary. At age 18, they're automatically deemed to be an adult and would be making their own decisions.
Now, how does age 18 play into that education piece?
Well, for education piece, actually, again, at age 18, they're entitled to make their own decisions. At that point, we'll be looking at some kind of a transition from the high school into an extended program for job training or for future training of life skills. If the child is age 18, they can make that decision on whether they want to engage in that program or not, unless we have that guardianship in place.
Okay, so once you put your child into that program in the school system and you continue until that child reaches the age of 21, what's going to happen at that point?
After 21, that child would actually then leave the high school program, that extended program, and then we'd have to look into some kind of maybe day program services, or we might be looking at transitioning to a group home at that point.
And what about Social Security?
Social Security disability would also be something you'd want to apply around age 18. We want to make sure that our financials are in place to make sure that child does qualify for Social Security disability, and that would include the potential of needing to establish a special needs trust as well.
So that's another step in the process. What's a special needs trust?
A special needs trust is actually an avenue for parents to put money into. It's a separate trust bank account. Those parents can put money into that, and that's no longer deemed to be the income of the child. Okay. Those monies can be set aside for future care. That money can be used for things, medical services or additional living expenses for that child.
Now, one of the things that in our family law practice here, we are encouraging parents to do is to consider support on an indefinite basis. Is that correct?
Correct. So if mom and dad are no longer married, or they were never married, one avenue for parents is to actually file for child support, essentially, post age 18, which is, we call it 513.5 support because that's the statute number. Mm-hmm. But courts have discretion to actually apply that and give continuing support for the parent who has the primary role.
Now let me make sure I understand that 513.5 support can then be deposited into the supplemental needs trust.
That's correct.
And then it can avoid being income of the child so as not to interfere with any type of Social Security or other rights the child would have.
Illinois has actually specifically written into our statute that the 513.5 support could be put into a trust to ensure that we qualify for not only 513.5 support, but we could still get Social Security disability.
Well, it sounds to me like a parent that has a child with special needs needs to plan going forward what it is that they're going to do. Now, you know, a lot of parents are sitting there thinking, well, you know, the situation could change. Maybe today we're in the situation, but not tomorrow. Why should a parent take care of this?
Well, essentially, you know, we can always make changes later down the road. If the child is actually making wonderful progress and can actually make their own decisions, we could, dissolve the guardianship, or the child could file to do a limited guardianship. There are options, but really what you're looking at is how you're going to make decisions now, and we can make changes in the future if needed.
Got it. You know, I think a lot of parents are fearful of spending the money when the child turns age 18 as well, and it's an investment. So if you have a child with special needs, you really have to look at this differently.
Absolutely.
It really is the remedies and the steps that need to be put in place.
And it's actually going to set you up for success in getting the services the best way you can, actually through other funding programs as well. If you don't have the right pieces in place, the special needs trust, for example, and the guardianship to make those decisions, you may lose out on other benefits actually.
Got it. So if you're listening today and you have a child with special needs and maybe you haven't taken care of your business already and they're over the age of 18 or they're approaching the age of 18, or if you just want to sit down and look at what planning options might be available both to you through family law or estate planning, please contact our office. Amy can meet with you. Terrence Fogarty, who does our estate planning, can meet with you, and we can move forward to give people the information, because knowledge is power, right?
That's right.
Take care.
Thank you.